Brian Kohberger's defense attorneys had filed 13 motions to suppress evidence and a motion for a Franks hearing. There's been court action on all of that. And what does that say for the future of the Brian Kohberger Idaho 4 case?
We have vacuums and Franks hearings. I'm Lainey Law.
And I'm attorney Andrew Myers.
And this is starting to sound like things are getting a little crazy in the Kohberger case.
Well, as I said in the intro, 13 motions to suppress evidence and a motion for a Franks hearing to test whether law enforcement intentionally misstated things in affidavits. They were all filed, and with just 4 motions, 1 on the Franks motion and only 3 on the 13 motions to suppress, the judge denied everything. But there was some interesting little details in some of the paperwork, the orders that were issued by the judge. So let's take a look at the order on the defendant's motion for a Franks hearing, denying it. And the judge, as he did with swatting down the death penalty motions, did a lot of research. People say, do your research. This judge and or his support staff did an awful lot of research. So in denying the motion for the Franks hearing, the judge pointed out, obviously, that the defendant is requesting a Franks hearing, claiming law enforcement intentionally or recklessly misrepresented and or omitted several material facts in their probable cause affidavits supporting various search warrant applications. These misrepresentations or omissions, according to the defendant, affect the validity of 17 different search warrants. Remember that? It was for AT&T and Amazon and a lot of others. And the hearing, of course, was held on January 23rd. In the interests of evidentiary efficiency, the court permitted a full Franks hearing on the motion only insofar as it pertained to the alleged omission of information regarding the defendant's identification through investigative genetic genealogy. On the remaining charges, the court permitted argument on the defendant's proffer as to whether the defendant had satisfied his burden to warrant a subsequent Franks hearing. So what that means is the judge has said, no, we're not going to have any Franks hearings. We did have a Franks hearing on the IGG, and no, the affidavits were okay. But why did the judge say that the defense is not entitled to the Franks hearing on all the other warrants that were used? He points out that the standard in a Franks motion is that the trial court's determination as to whether a representation is false and whether a misrepresentation or omission was made knowingly and intentionally or with reckless disregard for the truth are factual determinations reviewed under a clearly erroneous standard. So, in other words, if he's wrong, what he's saying at the very beginning, he realizes that things can be appealed, right? If his judgment that there should be no Franks hearings on any of the other issues outside of the IGG, and it goes up to a higher court, their standard in reviewing his action in this order here is whether or not he was clearly erroneous. Boy, oh boy, oh boy, that's a pretty wide standard, wouldn't you say?
Clearly erroneous is a strong bar, I suppose. Clearly is a little subjective.
I would say clearly erroneous. I mean, we all make mistakes. I've made mistakes, and the commenters point them out all the time. But clearly erroneous would be, I think, I know that punching somebody in the nose is wrong, but I'm going to do it anyhow. I don't know. If a defendant makes a substantial preliminary showing under Franks, the matter moves to an evidentiary hearing where the defendant must establish by a preponderance of the evidence that intentional or reckless falsehoods were included in the warrant affidavit and were material to the magistrate's finding of probable cause, or that material exculpatory information was deliberately or recklessly omitted. So it doesn't come right out and say they got to prove that they were lying, but deliberately or recklessly omitting. So it's not just that they are deliberately misstating something, but notably in Ann Taylor's arguments that they omitted something that should have been in there. So in issues 1 and 2, defendant challenges Exhibit A, which is a probable cause statement that the individual investigative officers appended to their affidavits in seeking search warrants. And we've gone over the PCAs before. As defendant notes, Exhibit A was a working document drafted as a group effort among the multiple investigative officers working on the homicide investigation. In their respective search warrant applications, the officers submitted and swore to Exhibit A as their own, even though it was the product of collective effort and not necessarily limited to the swearing officer's own investigation. In issue 1, defendant challenges this approach, arguing that Exhibit A was treated as a wild card to easily get a warrant. Defendant has not met his burden under Franks on issues 1 or 2. First, it is not improper for law enforcement seeking a warrant to swear to matters within the collective knowledge of other officers involved in the same investigation. Second, defendant has not demonstrated in his proffers any misrepresentation or omissions, much less than they were made intentionally or recklessly or had any effect on probable cause. Do you know what the really dangerous thing about this is, in my opinion, as somebody who's tried cases? Now, if I'm cross-examining you on the stand and I say to you, Laney Law, isn't it true that on such and such a date at such and such a time, you crossed Main Street? You'd say, no, I don't remember. Now I bring up an affidavit and I say, Laney Law, in your affidavit that you provided, 3 days after, much closer in time to your having done that, you said, yes, I did cross Main Street on such and such a date, such and such a time. And I cross-examine with you and I impeach you, and now your credibility is down the tubes.
Erroneous mischaracterization of when I went down Main Street.
Scurrilous allegation on my part, but I made this horrible example just to emphasize a point that that's easy. That's like shooting fish in a barrel. Suppose you and all 30 of your friends went to the football game, and then later you denied it. Now, all 30 of you write an affidavit, but only you sign it. Only you sign it. Now I'm cross-examining one of your other friends, and they say, "Well, I don't know what's in that affidavit. I can't say that. Only Laney Law over there signed it. I mean, I'm not responsible." And they pass the buck. That's what this is all about. Now, all of these officers, whether they're Idaho State Police, whether they're FBI, whether they're the multiple officers at the Moscow Police Department, they can all say, "Well, I don't know. That was somebody else's job. I don't know. That was somebody else's job." Is it really true that Dylan Mortensen said that she was drunk and she didn't really remember? Oh, well, I don't really know. That was somebody else. So that's the danger of this. And, the judge did, in fact, and I can't malign the judge because I'm not licensed in Idaho, and he cited Idaho law. And so he certainly, I would have to say he certainly is correct on Idaho law, but it just, pursuant to my stupid examples, I don't think that that's right. It is well settled that statements of law enforcement officers that are based upon the observations of fellow officers participating in the same investigation carry a presumption of reliability. So your other 29 friends who didn't sign the affidavit, but their statements are in there, they're presumed reliable.
My 29 friends, 25 of which probably had more than 3 drinks.
Yeah, exactly. Defendant acknowledges that a warrant can be based on law enforcement's common knowledge, but argues that officers cannot sign a collectively drafted affidavit as their own without identifying who did the work described therein. Otherwise, it misleads the magistrate into believing that the swearing officer drafted the affidavit and permitted the work therein when it was a collective effort. This hyper-technical argument has no traction. That was a nice way of saying nah. And he cites Idaho law. That's fine. Importantly, the Exhibit A, as challenged by defendant, included statements alerting the magistrate that the affiant was assisted by other law enforcement agents, and that the information contained within the Exhibit A was based on information provided by these other agents. See Blaker Exhibit A. I am being assisted by other officers of the Moscow Police Department, members of the Idaho State Police, and agents of the Federal Bureau of Investigation. There it is. As found in Wilson, this is sufficient to allow the reviewing magistrate to reasonably infer that the information within Exhibit A came from not only the affiant's personal knowledge, but the knowledge of other law enforcement investigating the crime. Moreover, given the breadth of information in the affidavit, it is readily apparent that the affiant did not perform all the work identified therein on his own. Further, defendant has not cited to a single case supporting the proposition that law enforcement's use of a working probable cause affidavit is improper. So there it is. In sum, defendant has failed to make the requisite showings under Franks on issue 1. Further, under no circumstances could it reasonably concluded that had the swearing officer disclosed which members of law enforcement provided which piece of evidence, the magistrate would not have found probable cause. So that's kind of a practical argument. He's saying that the defense couldn't provide any law to us, but it just doesn't seem right to me, because an affidavit, any affidavit that I have ever produced for a client or a witness, the purpose of an affidavit is to kind of take a snapshot in time, to kind of confirm facts that later they might change it, and that's the danger. But it's a statement of a person. If I made you do an affidavit, that's your statement. But now if there's 30 other people in the room, it's not their statement. It just seems like a fuzzy math, as a prior president said. It's a funny, fuzzy kind of a standard. So now, remember Dylan Mortensen and all the talk about Dylan Mortensen, the contention by Ann Taylor was that the probable cause affidavit cherry-picked her statements. And it just said these things like she saw the guy with the bushy eyebrows, he was wearing a mask, he was 5'10" or larger, and that type of thing. But in fact, the statements that she gave, 2 or 3 of them actually, right after November 13th, the day of the loss, had some statements that really called her credibility into question. And the court said, yeah, so what? Dylan Mortensen's accounts were consistent and accurately summarized in the Exhibit A. The draft Exhibit A circulated by law enforcement included the following description of statements DM made during her interviews with law enforcement. DM made statements during interview that indicated the occupants of the King Road residence were home by 2 a.m. and reportedly asleep by approximately 4 a.m. This is with the exception of Kernodle, who received a DoorDash at about 4 a.m. And we're really up on this stuff. We really have all heard all of this. Where's the one that I really wanted to read to you? She stated that she was awoken at approximately 4 by what she stated sounded like Goncalves playing with her dog in one of the upstairs bedrooms, which were located on the 3rd floor. A short time later, Dylan Mortensen said she heard who she thought was Goncalves say something to the effect of "there's someone here." A review of forensic records associated with a download of Kernodle's cell phone indicated she was likely awake and using TikTok at approximately 4:12. Okay, so far so good. Dylan Mortensen stated she looked out of her bedroom but did not see anything when she heard the comment about someone being in the house. She stated she opened her door a second time when she heard what she thought was crying coming from Kernodle's room. She then said she heard a male voice say something to the effect of, "It's okay, I'm here to help you." At approximately 4:17 a.m., a camera at 1112 King Road picked up audio of what sounded like a struggle coming from off camera. The security camera is less than 50 feet from Kernodle's bedroom wall. The struggle lasted less than 1 minute, and unintelligible sounds can be heard. Dylan Mortensen stated she opened her door for the third time after she heard the crying and saw a figure clad in black clothing and mask that covered the person's mouth and nose walking towards her. Dylan Mortensen described the figure as 5'10" or taller, male, not very muscular, but athletically built with bushy eyebrows. The male walked past her, and as she stood in a frozen shock phase. As the male walked towards the backsliding glass door, she locked herself in her room after seeing the male. Well, okay. The court acknowledges that this portion of the draft was incorporated in varying degrees, and it's okay that she later said that she may have been under the influence. Here's something that I'd never heard before. While she did not tell Officer Nunez that she noticed the intruder carrying a vacuum-type object in his hand, she did convey that information to Detective Mowry later that day, as well as to Detective Gooch a few days after that. I've never heard that before. Have you?
About the vacuum? Not at all.
Is this the? I've seen some other commenters say, "Is this the kill kit?" Remember early on, it was mentioned that, to do a crime with this efficiency and with this speed, and if you studied BTK, which he did under his professor in Pennsylvania, BTK would always go into his crimes with a kill kit. So
which also could explain as to why she wasn't, emmed off, because if he already had everything uncontrolled, it would be more risky to go after her on top of that. Presumably. No. I've never been in that situation, thankfully.
No, me neither. There's not one statement in the affidavits regarding the intruder that cannot be traced directly to DM's words. Consequently, defendant has not demonstrated an intentional or reckless false statement or omission of material exculpatory fact with regard to enforcement's recounting of her descriptions. I have a problem with that because right here it says, again, I believe I was very drunk. I didn't know how much of this is real. I don't know if my mind was doing whatever. I don't know if any of it, half of this stuff, I don't know if it's a dream or it's real. I just have no clue. So the court is like, wait. Or the court should have said, wait. She also said her memory was fuzzy and cloudy, and she could not differentiate if anything is real or if anything is a dream.
I'm dying also, how, sorry to interrupt you,
no,
but with she's saying I can't remember this, and they thought that person was holding a vacuum. This is silly, but there's so many different interpretations of what a vacuum even could look like. Was this person holding a big object? Was this person holding a more narrow, long object? And then on top of the, I don't even know what I was looking at is, there's
how would you
so many
characterize
variables.
it as a vacuum? There's vacuums you strap on your back. There's vacuums you carry in your hand. The little ones you use for your car, or I should use for my car. There's ones you push along the floor. So but right there, she's saying, I don't know how much of this is real. And they're basing an affidavit on that. Are you serious? She states her memory was fuzzy and cloudy, and she couldn't differentiate if anything is real or if anything is a dream. This information was not included in the Exhibit A's, plural. According to defendant, this information was crucial to allow the magistrate to properly evaluate DM's reliability, and its admission was material and exculpatory. Of course it is. I mean, if you're basing your probable cause affidavit on somebody who's drunk and they admit they don't even know if it was real, give me a break. But Judge Hippler says the law does not favor defendant on this argument. Probable cause is determined by examining the totality of the circumstances and making practical common sense decisions, whether giving all of the circumstances set forth in the affidavit before the court, including the veracity and basis of knowledge of persons supplying hearsay information. There is a fair probability that contraband or evidence of a crime will be found in a particular place. And they, cite case law. So the Franks motion for a Franks hearing was shot down on a bunch of different grounds, but we've summarized it. As to the motion, I just find that crazy. I find that to be a very material omission, that a witness on whose testimony the arrest and imprisonment for now well over 2 years is based on somebody that admits they were drunk. I mean, that's just, I'm speechless.
I can understand too, I guess, from like her perspective, where in that traumatized state, like you don't really know what's real and what's not. But this whole case, even just how long it took for 911 to get there, there's so many different layers in all of that.
Yeah. Now, with respect to the motions to suppress, motions to suppress the warrants on which the arrest was based, motions to suppress the warrants for all of the other evidence, whether it was from Amazon, AT&T, and all the other places, they were all denied. Now, we, unlike the people that can go on for 2.5, 3.5, 4.5 hours, we have other gigs, and we both are under some pressure today. So we're going to ask you down in the comments. Some of these motions to suppress have some really interesting information in them, kind of like Dylan Mortenson's vacuum cleaner. So let us know down in the bottom whether you would like us to go into more detail on the motions to suppress the arrest warrant for the Pennsylvania arrest, the order on defendants' motions to suppress regarding AT&T, Google, the USB drive, Apple, and Amazon, or the interesting order. Which one did I miss? The motion to suppress the genetic information that was shot down. I found interesting the arrest warrant for the Pennsylvania warrants in the apartment search. Had some interesting language. The judge, again, gives some background. A suppression hearing on the portion of defendants' motions at issue in this order was held on January 24th, during which the court received testimony from Detective Corporal Payne, Detective Mallory, both from the Moscow Police Department, and the court found the detectives to be credible and reliable. Okay. So in this case, defendant was informed of his Miranda rights. Interview subsequently began. 2 issues before the court, and I found this interesting. Exigencies excused law enforcement's full compliance with the knock and announce. Remember when they went into his home and then blasted down the doors? It is undisputed that law enforcement executed an abbreviated knock and announce prior to entry into his parents' home in Pennsylvania at 119 Lambston. According to the state, however, compliance was excused by exigent circumstances, namely law enforcement's belief the defendant was destroying evidence of the crime and that compliance with the knock and announce would have placed the officer's safety in jeopardy. Defendant argues these are not true exigencies. He notes that he was surveilled by law enforcement prior to the execution of the warrant, and there's no evidence he was seen with weapons. And this gets back to what we've said previously, that he was seen running, he was seen going into a drugstore. Why couldn't he have been arrested peacefully? But that wasn't the issue. The defendant pointed out that unlike in a previous case, law enforcement had no knowledge that defendant had a prior criminal history, a reputation for violence, or was a gun aficionado in that other case. They did not see him with a weapon, and therefore there was no reasonable basis to fear for their safety. At most, he argued, law enforcement had nondescript fears. The evidence demonstrates that while preparing to execute warrants, law enforcement identified defendant in the early morning hours as he turned on a light in the kitchen and then proceeded into the garage where his vehicle was believed to be parked. Law enforcement was aware that the defendant was suspected of having driven that vehicle during the commission of the homicides and knew it could contain evidence. Law enforcement then saw vehicle lights flash in the garage as if a vehicle was being unlocked or locked. Immediately afterwards, they saw the defendant again in the kitchen wearing rubber gloves and handling a plastic baggie. Further, it was 1:09 in the morning, a time when most people would not be removing items from their car with rubber gloves. These observations gave rise to the reasonable belief that perhaps aware of law enforcement surveillance, defendant was destroying or secreting evidence of the crime. So they basically did the same with this that they did with the Franks motion. They basically said, well, okay, those are the facts, but the law in Idaho is such that it doesn't really matter. You know, the police, basically what the judge said here, the police could reasonably believe that the Mr. Kohberger was destroying evidence and or he might have posed a threat. So that justified that. Now, if we get enough comments, 5 or 8 comments that want us to delve more deeply into these motions to suppress, we will do it, especially the motion to suppress the IGG. That's one of the larger motions that has been talked about, largely because this case is hanging on a thread, and that thread is the single source touch DNA that was on that brass snap to the knife sheath. Now, if the defense had knocked out the IGG, that would substantially weaken this case. So if you want us to go into that or any of the other rationing in any of these denials to the motions to suppress, let us know in the comments and we'll do it. Lainey, I always put you on the spot and I always say I feel bad about it, but I always ask you, do you have any closing thoughts?
Well, no, I do appreciate you giving the audience an opportunity to let us know what they want to hear about, because it just does feel like all these documents come out at once. And I think, and you know, guys, correct me, I don't know, let me know your opinions on how you feel. I think a lot of the times, like especially with so many different documents, it really helps break down each one. And a lot of the times people don't. I think people appreciate the help of having someone to just go through it. So I hope that this was helpful and informative for you guys.
Okay, thank you very much for joining us. Have a good one.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.